Hello and welcome to the in-depth program. Today's topic of discussion is CAs, company secretaries and cost accountants are now under the Prevention of Money Laundering Act. So let's discuss about the background. Then we will discuss what is money laundering, Prevention of Money Laundering Act, what are the changes being done under PMLA, why have these changes in PMLA been undertaken, significance, and what is the response of financial professionals to these changes. So first of all, let's discuss about the background. Over the past few months, the government has been undertaking changes in the money laundering law, the Prevention of Money Laundering Act, that is PMLA. The latest tweak bringing in practicing chartered accountants, company secretaries, and cost and works accountants carrying out financial transactions on behalf of their clients into its ambit and allowing 22 financial entities, including Amazon Pay India Private Limited, Aditya Birla Housing Finance Limited, and IIFL Finance Limited, to verify the identity of their customers via Aadhaar. Now let's discuss what is money laundering. Money laundering is the process of making large amounts of money generated by criminal activity such as drug trafficking and terrorist funding appear to have come from a legitimate source. Criminal activities like illegal arms sales, smuggling, drug trafficking and prostitution rings, insider trading, bribery and computer fraud schemes produce large profits. Thereby, it creates the incentive for money launderer to legitimize the ill-gotten gains through money laundering. The money generated is called dirty money, and money laundering is the process of conversion of dirty money to make it appear as legitimate money. Prevention of Money Laundering Act. The PMLA was enacted in response to India's global commitment, Vienna Convention, to combat the menace of money laundering. These include United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances 1988, Basel Statement of Principles 1989, 40 Recommendations of the Financial Action Task Force on Money Laundering 1990, and Political Declaration and Global Program of Action adopted by the United Nations General Assembly in 1990. It is a criminal law enacted to prevent money laundering and to provide for confiscation of property derived from or involved in money laundering and related matters. It forms the core of the legal framework put in place by India to combat money laundering. The provisions of this act are applicable to all financial institutions, banks, including RBI, mutual funds, insurance companies, and their financial intermediaries. What are the changes being done under the PMLA? In March, the Finance Ministry amended the money laundering rules to incorporate more disclosures for non-governmental organizations by reporting entities like financial institutions, banking companies, or intermediaries. In addition, it also defined politically exposed persons or PEPs under PMLA as individuals who have been entrusted with prominent public functions by a foreign country, including the states or governments, senior politicians, senior government or judicial or military officers, senior executives of state-owned corporations, and important political party officials. The amendment was in relation to foreign PEPs and not domestic ones. On May 3rd, the Finance Ministry brought in practicing chartered accountants, company secretaries, and cost and works accountants carrying out financial transactions on behalf of their clients into the ambit of the money laundering law. The ministry has specified financial transactions carried out on behalf of their clients by these financial professionals, such as buying and selling of any immovable property, managing of client money, securities or other assets, management of bank savings or securities accounts, organization of contributions for the creation, operation or management of companies, creation, operation or management of companies, limited liability partnerships or trust, and buying and selling of business entities that will get covered under the PMLA. On May 4th, the Finance Ministry widened the list of non-banking reported entities to allow 22 financial entities to verify the identity of their customers via Aadhaar under the ambit of the money laundering law. Last month, the Ministry of Electronics and IT had proposed allowing a wide range of private entities to carry out Aadhaar authentication for a number of services, expanding the use of the digital identity beyond its ministries and departments. Now let's understand why have these changes in PMLA been undertaken. The amendments are part of a series of changes being undertaken in the money laundering law to plug loopholes ahead of India's proposed assessment later this year under the Financial Action Task Force. Like in the case of definition of PEPs, the tweak was done to define politically exposed persons under PMLA to bring uniformity with the 2008 circular of the RBI for KYC norms or anti-money laundering standards for banks and financial institutions, which had defined PEPs in line with FATF norms. Now, in case of CAs, company secretaries and accountants, lawyers and legal professionals seem to have been kept out in the definition of entities covered under the PMLA. While the professionals pointed out the exclusion, officials said the changes have been made applicable only for transactions where they undertake financial transactions on behalf of their clients, while regular functions like certification of accounts and financial advice, among others, for a fee are not covered under this change in PMLA. Now moving on to the significance. The changes in PMLA law assume significance ahead of the proposed assessment of India under the FATF later this year. India's possible on-site assessment is slated for November, while the assessment is likely to come up for discussion in the plenary discussion in June next year. Due to the pandemic and the pause in the FATF's assessment process, the fourth round of mutual evaluation of India has been postponed to 2023. Before this, the FATF had undertaken an evaluation for India in June 2010. The FATF has 40 recommendations related to anti-money laundering or counter-terrorist financing, which the member countries have to comply with. Now, what is the response of financial professionals to these changes? The amendments are expected to aid investigative agencies further in their probe against dubious transactions involving shell companies and money laundering, experts said. Many CAs took to social media to comment against the changes, stating that auditors and legal professionals have been left out. The changes have given rise to concerns amongst financial professionals that they could possibly not just face a penalty for non-compliance, potential run-ins with investigative agencies. The conviction rate in PMLA is very low, but the entire process is extremely difficult to go through. These professionals are already regulated by professional bodies set up under various acts of parliament, and such measures are uncalled for. The reporting entities shall be expected to maintain the record of all transactions and would be required to furnish these to the Director, Financial Intelligence Unit. The reporting entities would also be expected to conduct KYC before the commencement of each specified transaction and will have to examine the ownership and financial position, including sources of funds of the client, and to record the purpose behind conducting the specified transaction. Failure to meet these requirements could invite imposition of penalty by the Director, FIU, and even more action by other investigative agencies such as the Enforcement Directorate. The FATF conducts an assessment of the implementation of the anti-money laundering and counter-terrorist financing standards in India. This current notification has been issued under Section 2(1)(sa) of PMLA 2002. This section defines a person carrying on a specified business or profession. This section already includes gaming activity, registration authority, real estate agents, dealer in precious metals and stones. Now CACS CMA has been included in the list for certain transactions. They have now become reporting entity for the purposes of these transactions. As a reporting entity, they have to do KYC of all clients entering into above transactions and to maintain record thereof. So that's all for today. Stay tuned for the next episode. Thanks for watching.